Good morning, Jack.
Morning, Bob.
So today I want to discuss with you, ask you some questions about your posting yesterday about habeas trolling in the Trump administration. We heard about habeas from the president, from Stephen Miller, from his press secretary. So why don't we begin by your describing sort of fundamentally the point of the piece, and then let's get into some of the details.
Sure, thank you. So it was Stephen Miller gave a statement to the press last Friday afternoon, and it was widely reported over the weekend that what he said and that what was going on was that the administration was considering suspending the writ of habeas corpus, and the clear import was that the president himself was going to suspend the writ. We can talk in a bit about what the writ is in more detail, but basically the writ of habeas corpus is the vehicle through which someone who's in detention can go to a court and test the legality of that detention. The Constitution provides for a circumstance, we'll talk about it more, for when that could be lifted. So the claim was that the president was going to suspend the writ of habeas corpus. My piece was about pointing out that that's not actually technically what Miller said or what the president said. I thought that the press had not been careful in reporting what they actually said. I claimed that Miller and the president were being purposefully and strategically ambiguous, that they were trolling the press, especially Miller and the American people. I tried to go through and show pretty clearly how these were planted questions and pre-planned answers. And then I speculated at the end of the piece about what the aims of the troll might be. What were the strategic aims of trying to mislead, cause outrage, and the like? And that's how the piece closed.
Well, let's go to those strategic aims, and then we can talk a little bit about the law here. What are the potential aims that involved here?
So there's no way to know, of course, and it's clear that the administration likes to do this. It likes to cause outrage, even when it, and I don't, and I made clear in the piece, I don't know what they're actually considering or what their actual plan is. It's conceivable that the president is going to suspend the writ of habeas corpus. I doubt that very, very seriously for a whole bunch of reasons. I think it was designed to do exactly what it did, to have a weekend of headline news coverage claiming that, and let me be clear if I haven't been, that it would be unlawful if the president did this. And I go through the legal issues and we can come back to this, but it would be unlawful if the president suspended the writ of habeas corpus. And that's what provoked the outrage. What were they trying to accomplish? One, and this is speculation, one, it's playing to the base. The administration is extremely frustrated with the inability to follow through on the campaign pledge to deport millions of unlawful immigrants due to judicial process that is due to them. Another one was, and Miller was pretty clear about this, put pressure on judges. He basically said in his press statement, well, we might not need to do this if the judges do the right thing. And then third and more broadly, I just speculated on this general approach of kind of keeping the people, the populace, journalists, and the like on edge, distracting, making people anxious and nervous. I pointed out that this has a role in distracting people from other things that are going on. It has an exhausting effect. There's so much stuff going on. If you're focused on the possibility of this outrageous thing of the president suspending the writ of habeas corpus, you're not going to be focusing on the 10 other things that they're actually doing. And I went on in that vein for a bit. And then finally, I ended the piece by saying that I'm quite confident that there's just the joy of the troll, the joy of owning the libs, the joy of watching people's heads explode. It's clear that that's an element of it.
Let's go back to something you just said about the law and it being, in your view, clearly unlawful for the president to unilaterally attempt to suspend the writ. Stephen Miller, and granted, as you say, his comment was ambiguous, says the Constitution is clear on the question of habeas and the authority with which it would be suspended. Could you talk about the Constitution and your view of what the
Sure.
issues are?
Yeah, sure. So the suspension clause of the Constitution is found in Article 1, Section 9. And it says, and I'm going to read it, um, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. There are two parts to that sentence. The second half of the sentence is about the circumstances that trigger the suspension of the writ, and that is when in cases of rebellion or invasion, the public safety may require it. But then there's an ambiguity in the Constitution, or maybe a silence, I should say, about who gets to suspend the writ. And the Constitution doesn't specify that. It says it's in the passive voice. The privilege of the writ of habeas corpus shall not be suspended unless, but it does, and then it gives the conditions, but it doesn't say who gets to do that. The general consensus, the widespread consensus, and indeed the Supreme Court has in dicta said this in a couple of cases, is that it's Congress and not the president who has the authority to suspend. And that is, in fact, what's happened in the four instances in American history, depending on how you count, but the four instances in American history when Congress has either itself suspended or authorized the suspension of the writ of habeas corpus. The one counterexample, of course, was Abraham Lincoln early in the Civil War. For a couple of years, Lincoln himself suspended the writ or authorized his generals to do so. This was highly controversial at the time. Lincoln defended it. It ultimately was approved by Congress, and Congress itself authorized the suspension of the writ. But it's become clear since then through, I mean, just basically there's really very few people that believe, especially in the current circumstances, that the president would have the authority to suspend the writ. It's Congress's authority.
Let's assume for a moment that he decided to go with the historic, or Trump decided to go with the historic example and ask Congress to authorize the writ. I mean, that's still, speaking of controversy, would be highly controversial, correct? In
Yeah,
the current circumstances.
Congress would authorize the suspension of the
I'm
writ.
sorry, authorize the
Yeah,
suspension of the writ.
yeah,
Yes,
and
yes.
yes, and I say this in the piece. I mean, let's be clear. Given the current circumstances, when we're not subject to any foreign country invasion, not subject to a rebellion, it would be extremely controversial for Congress to authorize the suspension of the writ. But as I say in the piece, it would be 100, maybe it should be 1,000 times more controversial if the president himself did it. As the Supreme Court said in Boumediene, the writ, at least as the court understands it, is a separation of powers check on the president, on the president's, by the courts and by Congress, on the president's ability to basically take people off the streets and do with them what he wants. But yes, and one can imagine the president doing this, if the president asked Congress to suspend the writ, that would be a very controversial step because first of all, you're basically giving the president within the scope of the suspension free reign to do with people what he wants, independent of judicial review. Basically, you're wiping out any judicial review of the president's activities in that context. It would be controversial in any circumstance. It would be controversial if Congress did that in this circumstance, when, in my judgment, we have not been subject to an invasion or rebellion and the public safety doesn't require it. But the final point I'll say, and I say this in the piece, there are two separate issues there. One is, um, can Congress lawfully, consistent with the suspension clause, suspend the writ? I think the circumstances of cases of rebellion or invasion that where the public safety required are not met. But if Congress did suspend the writ, there's a separate question about whether the courts can review the legality of that suspension. And on that question, the conventional wisdom is that it's a political question for Congress to make. Now, that is not airtight conventional wisdom, but that is the dominant view, and it has lots of fancy jurists who have thought that.
And what's the argument to the contrary? They believe that the court has to stay out of it for political questions, reasons. There's another school of thought, maybe it's a minority school of thought. What would it be?
The basic idea is that the political question doctrine, that basically that there's law here to apply, that the Constitution doesn't expressly say that this is Congress's power to exercise, and that it certainly doesn't say that it's Congress's power to exercise alone. There are other provisions in Article 1, Section 9, where Congress is constrained and the court has exercised judicial review. And so the point would be that the court is competent to interpret these legal terms. Now, to be clear, even if the court exercised judicial review, I do think it would give deference, not absolute deference, but some deference to the political branches. I mean, whether the public safety requires suspension of the writ you can see as a political call. Maybe the court would just focus on reviewing whether there was actually an invasion, but there are legal terms to interpret, and you can make the case that those terms should be subject to judicial review. I'm, if we were in a situation where Congress actually suspended the writ in the current context, I actually don't know what the court would do, but I would be inclined to think that there would be five justices to say that that's a political question, depending again on the seriousness of the deliberations, the seriousness of the case that was made. I think it would be hard for the court to second guess that judgment.
To what extent do you think the court might be influenced by this background recognition now that Congress actually isn't playing a separation of powers checking function, that we have a separation of parties, but not a separation of powers? Do you think that that has sort of, if you will, suffused the consciousness of the court to such an extent that without saying so specifically, it might be motivated along those lines to intervene rather than not intervene?
I would say maybe in a normal administrative law case or executive order case, if Congress actually suspended the writ, that would mean that Congress had actually acted. And that Congress, and to be clear, they would be acting in favor of the president whose party is in control of the White House. But I just, this is speculation upon speculation, so I really don't know. But but I would think that the court would hesitate before second guessing that. Again, it would depend on the seriousness of the deliberation and the seriousness of the case that was made.
Let me ask you another question, which would require you, of course, again, as you necessarily have to do in these circumstances, to speculate about the administration's aims here. To the extent the administration may be wanting to put pressure on the courts, it's flexing its habeas muscles to some extent to try to drive the courts into a more pliant position on these cases it's so frustrated about. Why would they conceivably think that would put pressure on the courts? What would be the pressure point for the courts here? The offense, institutional offense here, if the president were to unilaterally suspend the writ, would be an offense against the Congress, not an offense against the courts. And so, why do they think that this, or why might they think that threatening the unilateral suspension of habeas or implying that the president might would put some helpful pressure on the courts to go more the administration's way in these cases?
I don't exactly know. I mean, Miller definitely suggested that in his statement. He said, of course, if the courts, we don't have to do this if the courts do the right thing. Um, you and I have spoken about this and written about this a lot. It's not at all clear, and I'll just zoom out a little bit. It's not at all clear how the administration's game playing and disrespect towards courts in this, here, this is an implicit threat, but in other contexts, threats and reading decisions narrowly and not really complying with orders specifically, or at least, focusing on loopholes and being late and not having answers to questions, the whole set of things they're doing towards courts seem to me designed to have the opposite effect that they think it will, that ultimately it will lead courts to not trust them and to not cut them breaks when they're making legal decisions. So I don't see why a court, for example, considering the Abrego Garcia case, would be worried that if I don't do what the administration thinks, they're going to suspend the writ. It just doesn't make any sense to me. I mean, maybe they believe that. I actually think it's mostly um, dramatics for the base. I just don't see how it would actually influence the courts. The threat, that is, would actually influence the courts.
There were some curious pieces to messaging. And again, we were asking you to speculate a little bit. But first of all, there was the suggestion that you cover in your piece that the question was a plant, and it was a plant with a uh, somewhat remarkably introduced commentator in the press room who was obviously ready to ask this question and was given quite the warm welcome by the press secretary, having lots of followers and being very popular. And he put the question that ultimately elicited that exchange in the press room. And then Stephen Miller on the White House lawn. Focusing on Miller for a second, is there anything unusual, risky, revealing, problematic about having Stephen Miller, who is not a lawyer, he doesn't really speak for the legal advisory circle around the president, be the one to give sort of speeches or lectures or however webinars on the subject of the suspension of the writ?
Listen, I can't assess whether it's prudent. I mean, this president has chosen to give Miller this role. This is something Miller does every week. He comes out and it's very hard to understand what the relationship is between the lawyers in the White House and the Justice Department and Stephen Miller. It appears to me that he's directing a lot of the legal action, and he often comes out in the press room or on the lawn and gives a lecture about the law and presidential power and the like. So this is a commonplace. It happens all the time. Is it problematic? I'm going to throw the question back to you. In my view, this certainly would never happen in a normal administration. I'm going to let you speak to this. This would be the purview of the White House counsel and the Justice Department. But obviously, the president can use his advisors the way he wants. If he wants to send his bulldog political advisor out to make points on law, he can do that. And it's been happening so persistently. And Miller often, almost always, misstates the law. But it's been happening so persistently that it seems, authorized and accepted, and they must think it's a good idea. But how does it compare to a normal White House? I mean, how would you even compare it?
It's very difficult for me to see how this helps. I mean, I think as base communication, it may well be very effective. I can also see administration officials who are not lawyers coming out and making a basic statement. The president will always comply with the law. We believe this is consistent with the law. But Miller decided to give a little mini lecture on the topic to suggest that he knew something about the law. And as you point out, he's almost always wrong, either deliberately or carelessly, whatever the circumstances may be. And this goes again to something you and I have talked about time and again, which is this is not helpful to the legal presentation of this administration. That they have people who not only don't hold positions of responsibility, but when called upon to speak to legal issues, they do it controversially, poorly, inaccurately. I don't think any of that helps them. I don't know that it makes much of a difference in the Congress. I don't know whether Stephen Miller makes a Republican squirm. I can't imagine it helps them with the courts following the course of debate in this administration.
But Bob, I mean, that would be true in a normal administration, but this is part of a larger program where the administration is clearly, to put it nicely, inattentive to the law in general. I mean, it's not just Miller coming out. And by the way, he actually, all he did was, this is what part of my piece, he really just quoted from the suspension clause without saying it's the president's power. So he went on to say some other legally problematic things, but all he said on habeas was to quote the suspension clause. But in general, he's all over the map and usually not accurate on the law. But this is an administration that, through executive orders and in speeches by the attorney general and by the president and by Miller and many others, misstates the law. The executive orders, many of them are clearly unlawful or clearly poorly drafted in way they could have been better drafted to be more lawful. This is an administration that is openly disrespectful via the Justice Department to the lower courts. So it's not just Miller, it's part of a program, and they clearly believe that it helps them. I mean, either they clearly believe that it helps them or they're utterly inattentive to consequences. And I have to think that there's enough rationality for it to be the former. But it's a puzzle as to how it works.
Yeah. In the short term, I could see that they might think, look at what we've accomplished in this first 100 days. We've flooded the system. We've changed the debate. And we're completely restructuring the government, all of that. But this inattentiveness to consequences over the long term could come back to really haunt them. They may not be able to imagine right now how, but when they really, really do need to be credible, they will have traded all that credibility away, at least on these legal issues. And I just don't see how any thoughtful lawyer in the administration, even if they were completely committed to the president's program, could think that was a wise strategic course for them to chart.
I'm quite confident that the poor souls in the Solicitor General's office who are going to have to defend this stuff ultimately in the Supreme Court are not happy with this. And in fact, Thursday, I said in an earlier piece that Thursday, when Solicitor General Sauer goes before the Supreme Court on this emergency orders question, is really the first time that the administration will appear before the court in a way where the court can ask it about its attitude towards courts. I expect there to be questions about that. So that should be interesting to watch. Can I just suggest that we wrap up by previewing something that you and I are writing about the emoluments clause and the airplane deal. Why don't you just kind of introduce the issue and give a preview of what we're going to be writing about?
There now seems to be a general recognition, even among some Republicans in Congress, that this president's disregard of conflict of interest norms that have constrained other presidents in the pursuit of financial interest while in office is extraordinary. It's really without precedent. And in our piece, the piece that we're working on right now, we chart how much it has changed, even from the first term, which was already controversial, to the current one. And just in recent days, we have the president engaging in some remarkable promotion of a meme coin that he has a personal financial interest in, that his family has a personal financial interest in, that involves a dinner, one-on-one meetings with the president by people who have an investment in the coin in which he has a financial interest. Plus, of course, um, we now hear that he may be accepting, certainly considering accepting, it seems inclined to accept a $400 million gift from the government of Qatar in the form of a luxury airplane that he would fly in lieu of the Air Force One that's currently at his disposal. And the question of foreign sources of financial support, setting aside all the other conflict of interest issues, is a question that is addressed and implicates in serious ways the foreign emoluments clause of the United States Constitution. And we'll be discussing that and also talking about potential avenues of reform, which it's high time be considered.
Great. Why don't we stop there and get back to work on that piece?
We'll do that. All right. Have a good day.
Thank
Thanks.
you.